Good morning. Are you Jacqueline Young? And Mr. Lewis, will your client waive the formal reading of the indictment and the motion?
He does, Judge.
Give me a second. Mr. Young, in cause number 250309, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from February 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up. And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Speak up. Because let me tell you something. I bet you're not talking that low when you're acting up like all these jail incident reports tell me. When you're calling names and you're acting a fool out at the jail. So use your big boy voice and answer my questions, just like you do when you're acting nonsense to those correctional officers out there. Because I bet you're not whispering to them, are you? Are you? Okay. Because how you act at the jail, how you act right now, all determines whether I even go along with this plea agreement. I don't have to. You're on a probation. I don't have to take plea agreements on any probations. If I find that you violated your probation, I can give you anything I want to in that range of punishment. And I can say, you know what, I'm not going to let you guys negotiate. That I don't have to do that legally. So you better be careful with your faces and your words and your attitude, because I've read all of these and I already don't have a good feeling. Do you understand? So you need to give me a better feeling if you want me to go along with this plea agreement. Does that make sense? Okay. So, again, before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in that case?
No objection, Judge.
It's admitted. Is there any evidence that Mr. Young is not competent?
No, Judge.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, in cause number 2137857,
Your Honor, it's a second amended. Just in the interest of economy, I would suggest we go forward on counts 1, 2, and 13. 13 being the offense he's already pled to.
okay, let me look at it. Thank you. I got it, thank you. So I have a second amended motion to revoke your community supervision. So you're on probation. We've got a probation for an evading arrest or detention with the use of a vehicle. And we've got 2 more evading arrest or detention?
The second evading is a misdemeanor enhanced to a state jail. And
it
count
was
20
right.
reads motor vehicle. That's incorrect, Judge. It's evading on foot with,
Okay.
with priors.
Okay, gotcha. And so this shows that you were placed on probation August 29th of 2022 for evading with a vehicle. And that was a 10-year sentence in prison that was probated for 5 years. Is that correct? And the state's elected to proceed on counts 1, 2, and 13. Count 1 alleges that you failed to report as directed to the probation department on October 2nd of 2024. And is that true or not true?
True.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
And then count 13 alleges that you were arrested for the offense of evading arrest or detention with the use of a vehicle February 26th of 2025. And is that true or not true?
True.
What's the status of the possession and the failure to ID from that date?
I believe the failure is, I think, still pending.
The failure ID is still pending next door, Judge.
And examining the probable cause affidavit from that date, I don't see that there would be a possession charge, Your Honor.
Okay.
I will double check and see if there's, I didn't see anything else that like filed or pending. At this point, I'll check and see if there's a lab report pending, but I don't think that's been filed.
Okay. So, let me look at something real quick. What I'm looking at, just so that you know, I'm trying to go back and find which administrative hearing talks about the allegation of his behavior to, it looks like there was something that happened with probation. One of the allegations. So I want to see a little more about that. That coupled with what's been going on in our jail may or may not affect my same thing. It's the same thing. You did the same thing to your probation officer that you're doing in the jail. Do you really think that your probation officer is going to go on a date with you? Do you really think that a correctional officer is going to go, yeah, when you get out of jail, you're the guy I want to date? You got in trouble for saying and talking like that to your probation officer, and now you're doing it when you're in jail.
Wow. The judge just connected the dots between the defendant's behavior on probation and his conduct in jail. Calling community service slavery and making inappropriate comments to probation officers isn't exactly the recipe for judicial sympathy. When judges talk about accountability, this is exactly what they mean.
Cursed loudly about the work you had to do for your community service, calling it slavery? You think community service is slavery? Do you think that?
No.
It's the same, I'm not taking 5 on the MTRP. I've already taken 5 on the other. Y'all can renegotiate or you can let me do it. So I'll hold everything right now. Y'all go visit some more, but that's the same behavior. We're not gonna reward that. All right, y'all go visit. I'll hold it instead of resetting it. I'll keep this paperwork, but I can make a modification if you come up with something different, but I'm not gonna do that. Let's see, so I already did that one. right, so we are back on the record in cause number 21-37857. And again, you're Jacqueline Young, right? And in that case, which is the motion to revoke probation, Mr. Young had entered pleas of true to counts 1, 2, and 13. There was an agreement for 5 years in the institutional division, which I said I would not accept. Have you guys had an opportunity to visit?
We have, Judge.
And what is the,
The new agreement is 8 years TDC.
all right, I'll take that. And Mr. Nichols, that's your agreement as well?
Yes, Your Honor.
All right, Mr. Young, again, I have some documents here, like the other case, that have your signature on them, that the state's marked as exhibit number 1. And before you signed these, did you go over them with Mr. Lewis? Speak up. And do you fully understand them also? And I have made the notation with everyone's agreement on the agreed punishment recommendation page that that's changed from 5 to the 8.
Yes, ma'am.
Yes, Your Honor. Thank
All
you.
right. State tenders number 1 in that case?
No objection.
It's admitted. And so, Mr. Young, I'm going to find that you entered your pleas of true to counts 1, 2, and 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with this agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. As a part of this plea agreement, I'm going to sign a dismissal in cause number 25 DCCR 0385. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. When you were here back in 2022, we went over the fact that you're not supposed to possess a firearm in Texas, correct?
Yeah.
Okay. It can still go worse. I mean, I got 2 more years. It's not funny. It's not funny to you, but I know you're upset about all this, but the only person you should be upset with is yourself, you know? So anyway, because of the judgment entered against you, you're not allowed to possess a firearm in Texas. I've handed you that admonishment. Be sure and read it again. We already went over it before. All right, good luck to you. You can go back with the bailiff. Good morning. Are you Christopher Falk? And this is cause number 24-1891. Mr. Falk is charged with assault on a public servant. There was a request to have Mr. Falk examined for competency to stand trial. Dr. Rapon did that evaluation. I've received that report dated May 30th of 2025. It has the finding that Mr. Falk is currently competent to stand trial. Is there any other evidence with regard to competency?
Nothing to question.
No, Your Honor.
All right, then based on that, I am going to find at this time Mr. Falk competent to stand trial. And do you need some time for an announcement, or are y'all ready to make an announcement today?
A little more time, Judge. I have talked to him a little bit since we've gotten the report back, but I do need to talk to state a little more and see if we can get it worked out.
All right, I'll reset that one more time, and then we'll see if we can get an announcement at the next court day. Is that your computer? That's okay.
Do I need to get the bailiff?
All right, we'll reset it. We'll get an announcement at the next court date. You can go back with the bailiff. Good morning, sir.
Good morning.
Are you Theodore Briscoe?
Yes, ma'am.
And Mr. Briscoe, in cause number 23-4535, is on probation for evading arrest or detention with the use of a vehicle. And in 23-6055, on probation for possession of a controlled substance.
Yes.
Motions to revoke those probation have been filed. Mr. Parker, announcements.
Your Honor, just for the record, I went to see him at the jail, and they told me he wasn't at the jail.
Oh,
So I didn't get to visit him, and
Okay.
he was here. I got to visit him this morning. I told him that the court would probably give us more time to go over it if we wanted to, but I think we just need to go through the motion.
Without an agreement.
Without an agreement, I think he understands that. Also, there's a drug charge that hasn't been filed yet, just for the court's knowledge.
Okay. And so, Mr. Briscoe, we can go through those motions today, get pleas of true or not true, or I can reset your case just a few weeks if you need more time to visit with Mr. Parker since he,
You'll be moving.
okay. So let me get that pulled up.
And they're the same violations on both cases, Judge.
Can I get 36055 printed, please? Oh, no, that's okay. I gotta make marks on it. Thank you. It's just hard to do when I do them both on the computer. All right, in each of these cases that we've talked about, Mr. Briscoe, again, I have motion to revoke your unadjudicated probation. In 20-34535, the motion shows that you were placed on probation March 15th of 2021 for the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? And in cause number 20-36055, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 15th of 2021 for the third-degree felony offense of possession of a controlled substance, and that was also a 5-year deferred probation. Is that also correct? Each of these motions allege that you violated your probation. Count 1 in each of the motions alleges that you committed the new offense of possession of a controlled substance January 5th of 2025 in Jefferson County, Texas. And is that true or not true?
That's true.
Count 2 in each case alleges that you committed the offense of assault causing bodily injury to a family member January 5th of 2025. And is that true or not true?
Not true.
Count 3 alleges that you committed the new offense of interference with an emergency request for assistance, January 5th of 2025. And is that true or not true?
Not true.
Count 4 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
That's true.
And count 6 in each case alleges that you were behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true in each case to counts 1, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find in each of your cases that you entered your pleas of true to counts 1, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing. Mr. Nichols, does the state anticipate bringing witnesses for either of those cases?
Yes, Your Honor, I'll have to call witnesses to prove up the two that
Sure.
you pled not true to.
Do you anticipate that taking longer than an hour or so?
No, I do not, Your Honor.
Okay, we'll just set it maybe at 11 on a regular docket day. I will ask probation to do an updated pre-sentence report. Mr. Briscoe, obviously anything that you think is important for me to know, make sure and get that information to Mr. Parker. He will present it to me on your behalf when we come back.
Yes, ma'am.
All right, we'll see you back at sentence. Yes, it's unagreed. God bless you. Good morning, sir. Are you covered, Alfred?
Yes, ma'am.
Mr. Alfred was previously in court, entered pleas of guilty in 3 cases, 2 assault on a peace officer, second-degree felonies, 1 harassment by a person in a correctional facility, a third-degree felony. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Go ahead, Judge.
Any additions or corrections to that report? And in addition, I have received a packet that you all should have received also of incident reports from the Jefferson County Jail. Have you also had an opportunity to review that?
Yes, sir.
All right, and it looks like the agreement was for a cap of 15 years in prison in each of these cases with dismissals in the other, is it 2 or 3 cases? 3, okay. The obstruction or, all 3 obstruction or retaliations would be dismissed, correct?
Correct.
Okay. Mr. Lewis, you may proceed.
Judge, this is a situation where my client suffered from some severe mental health issues, just from my time representing him from the time from the beginning to now. Just appearance-wise, a totally different person from now being medicated and sober and everything like that. He definitely suffered from some substance abuse issues, which I believe comes from the self-medicating. But I believe when he's going through these issues with his mental health issues, even, trying to self-medicate anything, it does not correct any issues. It only makes it worse. And just from the evidence that was presented or that we had from the cases at question, you can see that this was somebody who was going through some serious issues during those times. Now, as far as the jail issues, I know that seems to be a big issue as well. If you look at the dates on those jail issues, most of them around when he was first brought into custody, while he was still going through detox and getting acclimated to medication and things of that nature. So he was still going through a difficult period at that point, even when he was going through that. And probation even pointed out in the PSI report that he's someone that really a rehabilitative type situation, it will be better for him than just incarceration. It's a big ask in asking for some type of communication with the mental health caseload and things of that nature. He's more than willing to comply with whatever. I think he's at an age where he's tired of the cycle and wants to try to take advantage of whatever may be available to him to try to fix this issue so he can be in a more stable situation and environment. I think the time he has been on his medication and sober these last few months will give him a different insight. And Judge, that is what we're asking for, that, he's able to try to take advantage of some of those things I think will be very important for him. And I think even from the PSI report, you see these are issues he's had almost basically since a child, towards the mental health issues.
Mr.
Judge,
Smith?
obviously I disagree completely with what the defense attorney is saying in this case. His history, 12 misdemeanor convictions with 4 currently pending. This will be his 4th, 5th, and 6th felony convictions. He's been given probation. He was revoked before able to complete successfully the probation. He's had a long history of violence and some of the things he's done while he's in jail are heinous. The lewd conduct, the words, the throwing feces on more than one corrections officer shows what kind of person this man is. And I think 15 is probably a little weak, but that's the most that we can do under the cap, and that's what I would ask you to do.
Mr. Alfred, do you have anything to say, sir? No. So, Mr. Alfred, your attorney makes some good arguments because, and I see the dates, and I do think that there's been a change, it seems like, in the jail since you've been on some medication. The issue with me, for me though, is that you've had some opportunities to get some help in the past. You were given probation, that was revoked. You got out of prison, you reoffended, got a 6-year sentence, and couldn't have been out very long when you did what you did here. Golly, I'm not really sure what to do. Because Mr. Smith is right. You deserve every bit of 15 years for what you've done. You really do. What you did to the officers, what you did in the jail. I guess what is sticking out for me is that all of that nonsense in the jail stopped when you started taking medication in the jail. So, do you agree that you need medication?
Yes, man, that's another thing that I wasn't able to get my medication when I got out of TC. So it was like, dealing with society just didn't. And like my mind was playing tricks on me. And once I got medicated, I even feel like I know what's going on.
So I think what I'm going to do, Mr. Alfred, is give you an opportunity that you probably don't deserve, but if you take advantage of it and you stay on medication, it appears that you can just live. I mean, you've got training, you had some good jobs in the past. You know, you're not somebody that quit school. You just need to stay on your medication. And what I'm going to do today is give you an opportunity to do that, and I'm going to give you some tools up front to hopefully help you do that. I can assure you that if I do this today and you don't follow through with what you're supposed to do, I would anticipate that Mr. Smith will remind me of this, and he probably won't even have to. But here's what I'm going to do. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. I'm going to find sufficient evidence in each case to find you guilty. In cause number 24, DCCR 1291, I'm going to defer all proceedings and place you on probation for a period of 10 years. You will be ordered to follow all of the rules and conditions of probation, and I'll talk about some of those specific ones in just a minute. Cause number 24, DCCR 1292, also find sufficient evidence to find you guilty. However, I'm going to defer all proceedings for a period of 10 years, place you on probation. Cause number 24, DCCR 1143, also find sufficient evidence to find you guilty. However, I'm going to defer all proceedings, place you on probation for a period of 10 years. In each of those cases, I'm going to order a $250 fine. I'm going to order in each of the cases that you enter and successfully complete the special needs track of SafeP. That gives you help for two things: the drug abuse that you're using when you're not on medication, and also it'll help you stay on your medication, and you'll get counseling for all of that. So you're going to have all of the tools that you need when you get out to be successful, stay on your medication, stay out of trouble. And if you don't do that, the reason I deferred these cases instead of a straight probation where you were convicted is because in two of those cases, if you violate, I can sentence you anywhere in the range of punishment, which is up to 20 years. So that cap of 15 years is gone. I have the whole range of punishment. You're ordered to comply with any and all recommendations of MHMR, whoever you end up with when you get out, of SafeP. That includes, if they say you need medication, you have to take medication. If you stop taking your medication, it's a violation of your probation. You're going to be back in here, you're going to end up going to prison for a long time. Do you understand?
Yes.
If you get to SafeP and for whatever reason, you think that it's going to be a good idea to act up in SafeP the way that you acted up in our jail, you will be back here on a motion to revoke before you ever hit the streets. Do you understand? It appears that that shouldn't be an issue. You haven't had an issue since June of last year and you got on medication, but I want to make sure you understand that you have to treat everyone with respect, follow the rules in our jail and in SafeP, and then you should be able to get out and again have the tools and the resources. You'll be on probation, you'll get to go to Spindletop, there won't be any excuses of I couldn't get my medicine and stuff like that. Do you understand? Do you have any questions? I'm handing you the trial court certifications in each of your cases. It shows these were agreements that I followed, and so you waived your right to appeal. I wish you the best of luck, sir. Thank you, Mr. Smith, Mr. Lewis. What's your name, ma'am? Are you Ava Musgrove?
Yes, Your Honor.
And Ms. Musgrove is charged in cause number 25, DCCR 0048, with the first-degree felony offense of murder. Ms. Perazzo is here as well as Mr. Gertz, and they have filed a writ of habeas corpus requesting that I set a reduced bond, which is currently set at $800,000. Ms. Perazzo, you may proceed.
Okay. And I think, did you want to,
You go ahead with her.
okay.
She's gonna call our client
Okay.
briefly to talk about our financial situation, and then I'm going to call Ranger.
Sure.
West.
If you'll please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can put your hand down. Go ahead, ma'am.
Okay, thank you, Your Honor. Ms. Musgrove, we're here today requesting the court to lower your bond that's currently set at $800,000 to at least $50,000 or less. Is that correct?
Yes, ma'am.
And currently, do you own a home?
No.
Do you own a car? Do you have any kind of investment or financial accounts at your disposal?
No, ma'am.
Do you have any source of income of any kind or help from anybody at this point? Financial help?
Yes, ma'am. What did you
Okay,
say?
okay, I'm sorry, that was kind of a lot. Do you have any financial accounts?
No, ma'am.
Do you have any kind of investment account that has money with large sums of money at your disposal?
No, ma'am.
Do you have any way to, at this present time, other than family members that could potentially help you, do you have any other way on your own of bonding yourself out
No, ma'am.
on the bond that's currently set at $800,000?
No, ma'am.
Okay. If the court were to lower your bond and you were able to post the bond through help of family members, which would be your mother, your father, and your brother, is that right?
Yes, ma'am.
Okay. Those would be the individuals that would be trying to get some money, some funds together
Yes,
to
ma'am.
help you.
Yes, ma'am.
Okay. How much money do you think they would be able to gather together amongst the three of them to post your bond?
Maybe 10,000.
Once you're released, if you were able to post bond, where would you live?
With my mother,
Okay.
my dad,
And what is your mother's address?
3855 Cleveland Street, Beaumont, Texas 77708.
Okay. Were you, well, let me ask you this. How long have you been in Jefferson County?
Almost 3.5 months.
In Jefferson County? No, in Jefferson, in the county of Jefferson. I know you're nervous.
My whole life.
Okay. So you've grown up here, right?
Yes, ma'am.
Did you go to school in Jefferson County?
Yes, ma'am.
Are all of your friends and family in Jefferson County?
Yes, ma'am.
Now, you already have a bond condition that would require you to wear a GPS tracking device if you're released. You're aware of that, right?
Yes, ma'am.
Okay. Do you know anybody, friends or family otherwise, that reside out of Jefferson County or out of the state of Texas?
No, ma'am.
Would there be any reason or any place for you to even try to go if you wanted to?
No, ma'am.
Okay. I'll pass the witness.
I have no questions for her, Your Honor.
All right, thank you. You may call your next witness.
Judge, we would call Ranger Brandon Bess.
All right,
Former
Ranger.
Ranger Brandon Bess.
You are still under oath from your previous hearing. We don't have to do that again.
Thank you, Your Honor.
Go ahead, Mr. Gertz.
Judge, I know you know this, but so the record is clear if we need it later. Ranger Bess, tell us about your experience in law enforcement.
I was a Texas Ranger for 11 years, a little over 11 years, serving in our regular Ranger division, and then as a cold case Ranger for 3 years. Before that, I was a criminal intelligence sergeant or agent, served in that capacity for 8 years. Prior to that, 10 years as a Texas Highway Patrol trooper. Prior to that, I served as a local law enforcement officer, both as a deputy sheriff and a city police officer for 1 year and 10 months before joining the Department of Public Safety.
And during that experience, did you have occasion, on few or many occasions, to investigate murder cases?
Many.
How many homicides would you guess that you've investigated?
Probably been a part of no less than 100, whether I was the lead or assist capacity or cold case capacity reviewing homicides. Could be much greater than that, but I would easily say at least 100.
Okay. And in this case, we've hired you to essentially do a shadow investigation of this allegation of murder involving Ms. Musgrove. Is that
That's
correct?
correct, Your Honor.
And what did you gather in terms of evidence, et cetera? What did you gather as part of that investigation?
Well, not first off, but as a part of it, was able to do an interview with Ms. Musgrove there in the jail, reviewed the documents that were presented by the district attorney's office and by the Beaumont Police Department, viewed some of the videos, though we had some issues with those because they were so large. They took a long time for Mr. Gert's office to get it to my office and get those downloaded, but have been able to view a few of those and just basically reviewing the case that the detective in this case put together so far.
Did you also interview independently witnesses that could describe to you the relationship between the decedent and Ms. Musgrove?
Yes, many of Ms. Musgrove's former educators I was able to talk to, and associates through her education in high school going back to junior high.
Okay. Were you able to determine if she has a criminal record or any kind of criminal history, Ms. Musgrove?
None to my knowledge, no.
Okay. And were you able to establish with those interviews the nature of the relationship between the decedent and Ms. Musgrove?
I was.
And did they live together at the time of this shooting?
They did.
And are you familiar with the concept of spousal abuse syndrome or family violence abuse syndrome?
I am.
And you're aware of the different characteristics that sort of show up in those kind of situations, right?
I am.
Or one spouse or one partner is particularly abusive of the other?
Yes.
Did you see signs of that in your investigation here in this case?
I did, and not only that, just even her demeanor today continues to describe that, for lack of a better term, yes.
And were you able to interview witnesses about the facts immediately surrounding the events that took place on the day of the shooting?
Just the review of the documents as well as speaking with Ms. Musgrove.
And do you think that the Beaumont Police Department in their investigation adequately considered the possibility of a Chapter 9 self-defense justification in this?
I don't.
Okay. Do you believe, and I'm not asking you for a final opinion, but based on what you've seen before, do you believe that that justification may exist in this case for self-defense?
I believe it may, yes, Your Honor.
Okay. And was the decedent, was she armed with anything at the time of the incident?
Not to my knowledge, no.
Okay. Where did Ms. Musgrove, to your knowledge, or based on what you understand, where did she get the gun?
It was a weapon that was possessed by both she and her partner. A handgun they possessed together. I believe it was a pink-colored semi-automatic pistol. There were also knives, or at least one knife that was described in that the detective noted in his report, as well as the notes about the other weapon. And, you know, to say that the victim in this case didn't have weapons, she had her hands.
Right. Well, and that knife is specifically what I was referring
Yes.
to in my previous
Yes, sir.
question.
We don't know about that. We don't understand yet where the knife came into play. I don't think the detective did at the point that he made his writing either.
Okay. And do you believe, based on your skills training experience, that this was a very isolated incident for Ms. Musgrove?
Based on her criminal history, her actions, etc., yes, this shooting absolutely was a very isolated incident. The assaultive stuff appears to go on back to their junior high days.
And the assault by the decedent
Yes.
on Ms. Musgrove, not
As
the other
well
way
as
around.
others.
Okay.
Yes.
And again, do you feel like if she were released on bond at a reasonable bond amount, that she would be a future danger to the community? Ms. Musgrove. Okay. Thank you, Judge. I pass the witness.
Thank you.
I have another question, Your Honor.
All right, thank you, sir.
Thank you, Judge.
Any other witnesses?
No, Judge.
Mr. Nicholas, what's the state's position?
Judge, again, I think lowering a murder bail to $50,000 is just nonsensical. And that's maybe a third degree level. For a murder, and I understand they have a defense theory that they're going to present with the appropriate time about either self-defense or justification of some sort. But $50,000 for a murder is not going to keep this community safe.
Mr. Gertz?
And Judge, I always just go back to the 17.15 factors, that the bail should be high enough to give reasonable assurance that she'll appear in court, that it's not supposed to be an instrument of oppression. We called Ranger Bess, obviously, to talk about the nature and circumstances of the offense and the allegation. But as you know, if we were to go to trial, 3836 would allow the consideration of the entire nature of the relationship of the parties, the decedent and the accused. And then, finally, obviously, the ability to make bail, which is why we asked Ms. Musgrove the questions that we did about her financial situation, and the future safety of the victim and the alleged offense, obviously, is not really an issue, but the community's safety. I think, Ranger Best has extensive experience in law enforcement, and it's his opinion that she is not a danger to the community based on her history and her lack of criminal history.
Okay, so based on the information that I have reviewed, for the record, I've reviewed the probable cause affidavit, listened to testimony. I'm going to grant relief in this case. I am going to set the bail at $500,000 in this case. If that bail is made, a GPS monitoring device would be required and home confinement unless further order of the court on anything like that. We'll get it set for the first available on the next hearing and move it along as quickly as we can.
And Judge, yes, we're going to want to move quickly on this
We'll
one.
be ready.
I appreciate you.
We
Thank
can
you.
go back with the bailiff.
This is probation with zero room for mistakes. Medication compliance, counseling, treatment programs, and strict supervision are now mandatory. If he violates these conditions, he could face decades in prison. The judge is offering an opportunity, not a free pass. Would you have taken the same approach, or would you have imposed the full 15-year prison sentence?